The three strikes law, a fairly straightforward premise. 3 crimes and you're out. And California's version is one of the toughest, or at least it was. Defendants can get 25 years to life for any felony conviction if they've already been convicted of 2 serious or violent felonies. But a serious felony includes, for example, shoplifting. Well, yesterday, a court in California ruled that when strike 3 is shoplifting videotapes or a car alarm from Walgreens, for example, the punishment just doesn't fit the crime. In fact, a 3-judge panel called it cruel and unusual punishment. This could affect hundreds, if not thousands, of other criminal sentences. So is this decision right? Joining me from Los Angeles, criminal defense attorney Leonard Levine, who was also a deputy district attorney in Los Angeles, and Brian Means, California's deputy attorney general, who handled one of the 3 strikes cases that was overturned yesterday. Mr. Means, let me start with you. A big defeat for you?
Well, it is. It's a big defeat for the people of California, as well as our legislature, who enacted the 3 strikes law by an overwhelming majority several years ago.
You know, we've heard about these cases in the press and in following some of these cases where there are these seemingly unfair results, where you're talking about, for example, in this case, you know, someone steals 3 videotapes and suddenly he's in prison for life. Isn't that overkill?
Well, I think there's 2 points that have to be recognized. First of all, the 3-strike scheme allows for the discretion both of a prosecutor to move the court to strike a prior conviction, and also the discretion of the court itself to strike a conviction. And those decisions will be reviewed by the State Court of Appeal for abuse of discretion, so the safeguards are built into the system itself. Now, I can only speak to the present case involving Defendant Brown. Mr. Brown just didn't simply steal an item from a store. Mr. Brown's a dangerous man. He was labeled by the State Court of Appeal as a chronic assailant and chronic thief. He has an extensive violent prior history dating all the way back to a juvenile. He has 2 violent juvenile offenses, 2 violent misdemeanor offenses as an adult, and 3 violent offenses, felony offenses.
Mr. Levine, when the voters of California voted to enact this law, there was a debate going on about this very type of case, and yet the voters still said, we want it.
Well, I guarantee you most of the voters, if you ask them today, would have no idea when they voted for the law that the 3rd offense could be a petty theft like stealing a videotape. In fact, Mark Klaus, whose daughter, Polly Klaus, was murdered by a repeat offender and who was one of the motivators for the 3 strikes law, was against the 3rd strike being a petty theft or possession of drugs or any minor offense. He was against it. The problem is most of the citizens who voted for it had no idea that the 3rd strike could be any offense. They thought it was 3 strikes, 3 serious crimes, and you're out. Plus, I don't think they even understood that if I committed as a 17-year-old juvenile 1 offense, 1 incident, robbing a liquor store, let's say, where there were 2 people behind the counter, that's 2 strikes right away. 10 years later, let's say, I'm getting my life back together, I slip up, I go in and I steal a videotape. 25 years to life, which is in essence a life punishment. I don't think the voters intended that. I think the court understood that that's not appropriate, and that's why we're having these
What about the point, though, Mr. Means is making, which is, you know what, if a court wants to, the court can just strike, or the prosecutor can strike one of the previous convictions, so it doesn't have to be as definitive as we're talking about.
It doesn't have to be, but there are 300 people in state prison right now who are there for life for committing a petty theft, a crime that normally gets you probation and community service.
All right, so Mr. Means,
obviously, they've made a mistake, and the law is saying, don't leave it to the discretion of judges and prosecutors, leave it to what's right, and that is what's right.
All right, Mr. Means, the impact. Does this mean that hundreds, if not thousands, of sentences are going to be affected as a result of this decision?
I'm afraid that may be true, Dan. The decision has language that could extend far beyond a situation present here where the 3rd strike involves a petty theft. Rather, it can extend to even circumstances possibly where the 3rd strike could be something as serious as a felony murder or a robbery.
Well, I don't think that's simply not the case, Dan. The court made it very clear the punishment should fit the crime. If the 3rd strike was an attempted murder or a robbery, these men would not have had their sentences overturned. It's only because of the nature of the 3rd crime, which in this case was stealing a videotape and a car alarm, that the court felt the punishment just did not fit the crime.
Mr. Levine, what about the point that Mr. Means made earlier, and that is that, look, these guys are bad guys, that the bottom line is, you know, these are not good guys who just you know, happened to steal a few videotapes from a store and they got caught and now they're serving life?
No one is saying they're good guys. No one's saying let them go. Under the current law, for each prior felony they committed, they could get a 5-year enhancement on their prison term. So each of these men were facing 10 to 15 years under the current law. That's enough of a punishment for stealing a videotape.
Mr. Means, final word.
Life is not appropriate.
Mr. Means, final word.
Well, I would hasten to point out that at page 2014 of the decision, the court does indicate that this may extend far beyond the present circumstances, and therefore I think we do have real concern that this may free the prison doors for some very violent criminals.
Gentlemen, thank you very much. I always love it when lawyers refer to the pages. You know, us lawyers, we always know that you have to cite to prove to people that it's actually in there. Page 2014. Anyway,
Nice to remember it.
Yeah, gentlemen, thank you very much for coming on the program. Appreciate it.
Thank you.
Thank you, Dan.